Hello all, let us continue with the next set of probable topics for the Prelims 2023 from Indian Polity. We've already seen two classes and now let us continue with the next set of probable themes for the exam. Let's proceed with the first question. Have a look into the first question. Consider the following statements regarding the parliamentary privileges under the Constitution of India. Parliamentary privileges in general is a very important topic, but this year there are certain current events that has happened with regard to the parliamentary privileges. Mr. Rahul Gandhi have made certain speeches which has been not acceptable to the opposition parties, and ultimately a part of his speech was expunged by the speaker. Recently in the Lok Sabha. What do you mean by expunction or expunged? Which means a speech which is made by a member of parliament may not be part of the official records. It can be kept out of the official records, although it may go live and people can watch it, but whatever is the speech that has been expunged will not be part of the official records of the Lok Sabha, and also it cannot be reported in the media. So this is what is called as expunction, or a part of speech being expunged. Now, who can expunge any speech that is made by a member of parliament? The Speaker Lok Sabha has a power to do that under Rule 380 of the House. So we'll have to understand how it is relevant to the parliamentary privileges. So this Rule 380 is very much related to the parliamentary privileges, for which we'll have to understand what is there in Article 105 of the Constitution, which provides certain set of privileges and immunities to the members of the parliament. A similar privilege is also given to the members of the state legislature under Article 194. It is a similar privilege. So first question is, what is a parliamentary privilege? A parliamentary privilege is certain set of rights and immunities which is given to the members of the parliament, which would enable them to perform their duties as parliamentarians very effectively. So for example, the Constitution explicitly provides that they have the right to freedom of speech in the House, for which whatever they say and whatever they speak, they are not liable for any proceedings in a court of law. The court cannot question them for whatever they have spoken in the houses of the parliament. This helps them to effectively speak and to make the government accountable. That is the idea behind it. So they have the right to freedom of speech, and they can also vote in the house of the parliament, for which they are not liable in any court of law. So these privileges are given both for the members of the parliament and the members of the state legislature. But however, the Constitution also envisaged that these privileges which is given to them should not be absolute in character. They have few restrictions. What the Constitution say? The privileges that they exercise under Article 105 and Article 194 is subject to what? It is subject to the rules of the House. Rules of the House. And it is also subject to certain other provisions of the Constitution. It is subject to the rules of the House and the provisions of the Constitution. When I say rules of the House, a similar rule that is made by the parliament is rule number 380. So what is rule number 380 of the Constitution is saying? Any person, that is any member of parliament, who speaks something objectionable in the parliament, which is unparliamentary, which is indecent, such languages can be expunged from the official records. And this power is given to the speaker. So whatever is a privilege, that privilege is restricted or it is subject to the rules of the House, and such a rule is Rule 380. And who will report this to the presiding officer? There is a media section within the Lok Sabha. The media section will bring it to the notice of the speaker, in case if the speaker is not aware of this, and then accordingly the speaker can expunge such content from the official records. Now the next thing, it is also subject to the provisions of the Constitution. When we say it is also subject to the provisions of the Constitution, based on the rules, the Speaker can do that. But there are certain things explicitly mentioned in the Constitution. Say, for example, the members of the Parliament cannot engage in what is known as criticizing the conduct of a judge. Then that may result in the contempt of the court. And hence, those provisions which is explicitly mentioned, they cannot engage in those things also. Subject to these restrictions, they normally have the right to freedom of speech within the houses of the Parliament. Is that the only privilege that they have? No. The Constitution says that they can exercise the right to freedom of speech, and apart from that, if they want any of the other privileges, the Constitution has given the power to the Parliament to make a law, and by that law they can expand the scope of the privileges. Who can make the law? The Parliament. However, the Parliament has not made a law till this point of time. And also, if you see in the Constitution, till the time the Parliament makes a law, it says that they can continue to exercise such privileges as existed just before the commencement of the Constitution. So today, if you see in the absence of the law, the members of the Parliament exercise right to freedom of speech, and they continue to exercise a number of privilege in the form of parliamentary convention. So what are the sources of parliamentary privileges today? It is through the Constitution and also through certain conventions. There is no law as such, and these privileges can be restricted through the provisions of the Constitution and also any rule that can be made by the houses. So this is the basic understanding you should have to solve this particular question. We are not only discussing just to solve this particular question, but anything that is relevant to what happens in the current affairs. Okay. So with this information, just come to this particular question. Statement 1. The parliamentary privileges are kind of special rights and immunities, as of course, that helps them to effectively perform their job, given to the members of the Parliament and of state legislature, which are presently regulated by an act of Parliament. So yes, these Article 105 and Article 194 gives the privileges to both the members of the Parliament as well as state legislature, which is not regulated by an act of Parliament. There is no law as of it. So though the statement is partially right, it's partially incorrect as well. So it's a wrong statement. The parliamentary privileges are subject to certain provisions in the Constitution and the rules made by the House. We already discussed that. So this particular statement is right. Which of the statements given above are incorrect? So the incorrect statement is option 1. That is 1 only. Let's quickly move to the next question, which is again a very important question in my opinion. And this question is especially related to the preventive detention in India. The preventive detention is subject to a lot of criticism. This year it is even very important because recently a close aide of Mr. Amritpal Singh, who is propagating the idea of separate state of Khalistan, has been arrested. And after his arrest, the close aide of Amritpal Singh, after his arrest, the family members of the person who was arrested was Daljit Kalsi. He is considered to be a close aide of Mr. Amritpal Singh. And after he was arrested, his family members, in fact, he was taken into detention by the government. After he was taken into detention, the family members went and filed a case in the High Court. And subsequently, the High Court asked as to what happened to Mr. Daljit Kalsi, why he was not informed, why the family members are not informed of his detention. Then the government has clarified that the provision under which Daljit Kalsi was arrested is not on the grounds of punitive detention, but rather it is on the preventive detention because he was arrested under the National Security Act. The National Security Act is a preventive detention law in our country. It's a preventive detention law. So the government clarified that because he has been detained under the preventive detention law, he may not exercise the same rights as he may exercise, as someone would exercise in case of the punitive detention. So in this case, we should also understand as to what is the difference between punitive and preventive detention. These are two different things mentioned under Article 22 of the Constitution. So what is the basic difference between punitive detention and preventive detention. Punitive detention happens by way of a trial. That means only after the trial is over, and if somebody is found guilty after the trial in a court, they can be punished in punitive detention. And in preventive detention, an individual is arrested even before he commits an offense, because the state feels that if he is not taken into detention, probably he might do something that might be affecting the interest of the state, and hence he is taken into detention even before he acts. So this is majorly preventive in nature. It's preventive or it is precautionary. It's a precautionary basis. It's preventive where it is based on the trial. Now please understand the next important difference is, in case of punitive detention, there are certain important rights that is available under the constitution. Say for example, anybody who is arrested and then subsequently the trial will happen, within 24 hours he has to be produced in front of the nearest magistrate. At the time of the arrest, he has to be informed of the grounds of the arrest. He should be allowed to consult with a legal practitioner. So all these things are available in case of punitive detention. But such rights may not be available in case of the preventive detention, because preventive detention is a separate set of detention. It's not like punitive, because the consequence, the negative consequence out of preventive detention can be much higher. So this is exactly what has happened in case of Daljit Kalsi, that the family members questioned the detention and they said that the basic rights were not available to him. Then the government has to clarify that it is preventive detention and not punitive detention. Now, what are the other things that we have to know about the preventive detention laws in our country? The constitution says that anybody can be detained only by a way of a law. That means you need to have a law to take somebody into detention. So for example, in this case, we have a National Security Act. The National Security Act is a law which is made by the Parliament that enables a state to go for preventive detention. Second question that should know, that only is it possible for the Parliament to make a law, or is it the state legislature can also make the laws? So under the Constitution, both the Parliament and the state legislature is empowered to make law on preventive detention. The only thing is, law made by the Parliament can have application throughout the territory of India, whereas the law made by the state legislature will apply only within the territory of the concerned state. Because preventive detention is an item in the concurrent list. So preventive detention is mentioned in the concurrent list. So both Parliament and the state legislature can make laws, although NSA is a law that is made by the Parliament. Now, apart from this, what are the other things that you should know with regard to the preventive detention? Now, is it necessary when somebody is taken into preventive detention to inform the grounds of the arrest? There is some element of discretion that is given to the government. If they feel that revealing this information will affect the public interest, then they can also deny giving the information, but otherwise they can reveal the information. The next question is, how long one can be kept into detention if they are detained under the preventive detention laws? The law says they shall be kept initially for a period of 3 months. Can the detention be extended beyond 3 months? Yes. If the advisory board, which is established under the law, based on which somebody is taken into detention, after 3 months of detention, the matter will be put in front of the advisory board. For example, the National Security Act provides for an advisory board, so the matter will be put in front of the advisory board. And if the advisory board is okay with the extension beyond a period of 3 months, then the detention can be further extended beyond a period of 3 months. That means in this way, you can prolong it for an indefinite period of time. That's not possible. The Constitution clearly says the detention at any point of time cannot be beyond the maximum period of detention that is provided in the law. That means, say for example, the National Security Act provides for a maximum detention of 1 year. So someone who is arrested or detained under the National Security Act, what is the maximum period for which they can be detained? The maximum period for which they can be detained, even if the approval is given by the advisory board, it can be not beyond a period of 1 year. Okay. So all these informations can help you in answering a question if a question comes from the preventive detention. Okay. Let's move to the next question. Again, a very important question. Look into this particular question. This question is related to the post of deputy speaker. I'll just come to this context. I'll come to the question, but before that, let us discuss the context as to why this particular question is important. Now, recently there was a PIL that was filed in the Supreme Court, and it was brought to the notice of the Supreme Court that the post of deputy speaker is vacant in the Lok Sabha, in the 17th Lok Sabha, not only in the Lok Sabha but also in 5 states. In 5 state legislature, it's vacant. So this was brought to the notice of the Supreme Court. The Supreme Court has already issued notice to the central government and also to the various state governments as to why the post of deputy speaker is lying vacant for a long period of time. And in this context, it becomes very important to understand as to what is the relevance of the post of deputy speaker and the constitutional provision that is surrounding the post of deputy speaker. So let us try to understand all those things with regard to by solving these statements. Come to statement number 1. The speaker and the deputy speaker of the legislative assemblies should be elected in a time-bound manner. So for which we'll have to understand as to what is mentioned in Article 93 of the Constitution and also Article 178 of the Constitution. So one is with regard to the Lok Sabha and other is with regard to the state legislative assembly. Both Article 93 and Article 178 says that the speaker and the deputy speaker should be elected as soon as possible once the new government is formed. So it is not saying any time-bound manner for which they have to be selected. It only says as soon as they have to be selected. But if you see the convention is the speaker is immediately elected after the house comes into session. Within few days, the speaker gets elected because the speaker is pivotal to the functioning of the Lok Sabha or for that matter, the legislative assemblies in the state. But by conventional practice, what happens with regard to the deputy speaker is the deputy speaker has no role to play as long as the speaker is there. The deputy speaker will preside over the house only when the speaker is not there. By convention, what happens? The deputy speaker is usually elected by the second session, if not in the first session itself, after the new government is formed. So that's the convention, but for some reason, the deputy speaker has not been elected. So look into the first statement. The speaker and the deputy speaker of the legislative assemblies should be elected in a time-bound manner. So it is not in a time-bound manner. It is only saying that it is as soon as possible. And there is a vacuum in the Constitution. The Constitution has not prescribed the time limit. That is probably why the post of deputy speaker is not elected. So you may ask a question, why the deputy speaker is not elected? By a conventional practice in our country, the post of deputy speaker is usually given to the opposition parties. Although nothing is mentioned in the Constitution, because the Constitution says that they have to be just elected by simple majority. So ideally speaking, the government has the majority to elect both the speaker as well as the deputy speaker. By a conventional practice, it is given to the opposition parties. Now I think many governments are not following this convention. That could be one of the possible reasons for this. And they don't want the post to go to the opposition. Second statement, the speaker submits the resignation to the Secretary General Lok Sabha if the post of the deputy speaker is vacant. So there is a constitutional problem. What the Constitution says, the speaker, if you want to resign from the post, he can submit the resignation to the deputy speaker, the speaker to the deputy speaker, and the deputy speaker can resign by submitting his resignation to the speaker. But what if the speaker is there and if the deputy speaker is not there? In such a case, the speaker can submit the resignation to the Secretary General of Lok Sabha. So this is again an important question. Okay. So this particular statement is right. Statement number 3. The speaker and the deputy speaker can be removed by a resolution passed by absolute majority in the House. This we already discussed in our previous discussion. They can be removed only by an effective majority and not by the absolute majority. The difference being, in absolute majority, you just take into account the total membership of the House. Whereas in effective majority, you take into account total membership minus the vacancies. That's the effective majority. That is, you calculate the effective majority by taking into account the effective membership and not the total membership. So this particular statement is also wrong. Come to the next statement. Any person, even without being a member of the House, can be elected to the post of the Speaker or the Deputy Speaker, but they have to get elected to the House within a period of 6 months. This statement is completely wrong, because one of the basic requirement for anybody to get elected to become a Speaker or to the post of Deputy Speaker, they should be a member of that particular House. First, they have to get elected to that particular House, then only they can contest election. So this particular statement is completely wrong, but although this is relevant in case of ministers who are appointed as a minister, not necessary that they are a member of Parliament or a member of state legislature. Within 6 months, they have to get elected to the House. But this is not applicable in case of the Speaker and the Deputy Speaker. Okay. So with this information, just try to solve this particular question. Statement 1 is wrong, statement 2 is right, statement 3 is wrong, statement 4 is wrong. Choose the correct options from the code given below. So the right answer would be option B, that is 2 only. That's the only right thing. Okay, so before I move to the next question, few more information just to cover up completely this particular topic. Okay, what if the post of Speaker is vacant? The Deputy Speaker will act as a Speaker. If the Deputy Speaker is not there, if both Speaker and the Deputy Speaker are vacant, then the President can appoint anyone to preside as a Speaker till the time the new Speaker is elected. But what if there is an absence? It is not that they are vacant. Maybe the Speaker has fallen sick, the Deputy Speaker has also fallen sick. In that particular case, when there is an absence, there will be a panel of chairperson within the House, and any one of them can preside over the House. Okay, so this is what is the provision in the Constitution. Very important topic for your exam. Let's quickly move to the next topic. Now, this is a very general topic because there's a lot of news that is coming with regard to the fundamental rights, specific news. But sometimes UPSC can ask you question from the general features of the fundamental rights. Very, very important. So just have a look into the question. Which of the following is true with regard to the fundamental rights provided in part 3 of the Constitution? So basically this question is about the features of the fundamental rights. Statement 1. They cannot be amended by the Parliament. So this question has already been settled by the Supreme Court. The fundamental rights can very much be amended by the Parliament under Article 368 of the Constitution. But what they cannot amend is any part of fundamental right that is also part of the basic structure. And for that matter, it is not just the fundamental rights which are declared to be part of basic structure. Any provisions of the Constitution which is declared to be part of the basic structure, they cannot be amended. So the only restriction upon the powers of the Parliament to amend any provisions of the Constitution is that something which is declared to be part of the basic structure. Otherwise, they can amend the fundamental rights. There is no issue with that. So what is statement 1? They cannot be amended by the Parliament. So this particular statement is wrong. Come to statement number 2. They check the arbitrary exercise of power by the state. This is very much true. What is the reason as to why the fundamental rights has become part of the Constitution? And in fact, there's a lot of debates that has happened in the Constituent Assembly with regard to the fundamental rights. The very idea is that they wanted to prevent the arbitrary exercise of power by the state. The state shall not arbitrarily exercise their power. And that's one of the reason, or the most important reason as to why the fundamental rights has been placed, because the moment the government is trying to take away the rights of the people, then the people can approach the court and they can get it enforced. So it is very, very important. It's true. Statement number 3. They provide absolute protection to the citizens. So this is not completely true. In fact, this particular statement is wrong, because although the Constitution provides for the fundamental rights, the fundamental rights that is provided in the Constitution, they are not absolute in character. And in fact, there's a lot of discussion that has happened in the Constituent Assembly that why don't we give the absolute rights? So the members in the Constituent Assembly, the majority members in the Constituent Assembly thought giving rights is okay, but giving absolute right is very dangerous, because absolute right, or the idea of giving complete freedom, by exercising those full rights or complete freedom, they can take away the rights of other individuals in the society. And hence, on the one hand, we'll have to give them the rights, but that should not be absolute. It has to come with reasonable restrictions. And that is why you'll understand most of the rights are also reasonably restricted on certain grounds, which is provided in the Constitution itself, which is provided in Part 3 of the Constitution itself. So the idea is to balance between individual liberty and public good. So they have to balance between these two things, and that was possible in the opinion of the Constituent Assembly only if there are certain reasonable restrictions. Okay, so they provide absolute protection to the citizens, so this is also wrong. So which of the statements? Choose the correct options from the codes given below. So the right answer would be option B. Let us proceed to the next question. So this question is related to the Bar Council of India. So the Bar Council of India was recently in news for certain reasons. So what is the context in which the Bar Council of India was in news? Recently, the Bar Council of India has allowed the foreign advocates or the foreign lawyers and the firms to practice in India. So earlier it was not allowed in a professional manner. Earlier it was only just fly in and fly out. But now the Bar Council of India has allowed the foreign lawyers and the foreign firms to be established and to practice in the Indian courts, provided they register themselves with the Bar Council of India. So this is a new development that has happened. In fact, it was welcomed by various sections of the legal fraternity, saying two important advantages out of this particular development. One, it can give a big boost to the foreign direct investment in our country, because any form of commercial disputes can be easily resolved with their advocates and their firms. Two, the second thing is it can also make India as a hub of international arbitration center. International hub for arbitration. So this is what is being found to be the advantage of this particular development. So in this context, this question may also be very relevant for your preliminary examination. So let us try to solve these statements. One, the Bar Council of India is a body established by an executive resolution that regulates the legal profession in our country. This statement is partially true, but it's not completely true, because the Bar Council of India is not a body which is established by an executive resolution, but it is a statutory body. It's a statutory body. It is established by an act which is called as the Advocates Act. Advocates Act 1961. So basically, what is a statutory body? A statutory body is something which is established by way of a statute, that is by law, that is either passed by the Parliament or by the state legislature. So it's not an executive body. An executive body is something which is created by an executive order. So for example, there's no law that is backing that particular body, but it is created by a government order, by an executive order. That is what is an executive body. Say for example, CBI is an example of a body which is created by an executive order. So for example, Niti Aayog is an example of body which is created by an executive order. And there's also one more thing which you should also have an idea. Say for example, apart from the statutory body and a body which is created by executive resolution, there are also certain examples of constitutional bodies. So what is a constitutional body? A constitutional body is something which is established by the Constitution itself. So for example, the Election Commission of India under Article 324. So we have other things also, the Finance Commission of India, the Comptroller and Auditor General. So these are all examples of the constitutional bodies. Come to statement number 2. Recently, the BCA has framed rules that enabled the foreign lawyers and the law firms to practice in India. So this is the latest development that has happened. and it is also found that it has its own advantage in our country. So this particular statement is wrong. So this is true. Which of the statements given above are correct? So the right answer is option 2 only. Let's move to the next question. So this question is very, very important for your examination. It is to make you understand the various types of writs that is provided under the Constitution, especially under Article 32 and Article 226 of the Constitution. Number of news items do come with regard to various writs being filed, because there's a lot of disputes with regard to the violation of fundamental rights. So in this context, it is also very important for you to understand as to what these writs are. So let me just read the question. A citizen of India belonging to a particular state feels that the Chief Minister, who has recently assumed the office after the election to the Legislative Assembly, does not have the necessary qualifications to hold on to such office. That means the citizen feels basically the person who is appointed as the Chief Minister does not have the qualification to hold on to the post of Chief Minister. Now please understand, under the Constitution there is no specific qualification for the Chief Minister. It is that he should be elected to the House, and to get elected to the House he has to have certain basic qualifications. Or if he is a person who is not a member of either houses of the state legislature, he should be eligible to get elected. So these are the qualifications that one should have to become a Chief Minister. In such a case, he wants to challenge the appointment of the Chief Minister in a court of law. What would be the appropriate writ by which he can challenge such appointment? So what is the writ that he can make use of here is the writ of quo warranto. It doesn't require much explanation. It is the writ of quo warranto, because quo warranto basically means by what authority. Or by warrant you are holding on to such an office. So that means whenever such a petition is filed, the court is going to issue such particular order towards the person who is occupying the office, and the person is liable to prove that in a court of law that he has the necessary qualifications to hold on to that particular office. So this is basically the understanding. In fact, such a writ was filed against then Chief Minister of Tamil Nadu, J. Jayalalitha. So it is not only filed against the Chief Minister, it can be filed against any public office of substantive importance. So this is what the court has said. So nothing is there in the Constitution. Substantive important means which has a lot of impact on the public. Okay. And in fact, in 2011, it was also filed against then the Central Vigilance Commissioner of India, Mr. P.J. Thomas. In 2011, the Supreme Court has issued a writ of quo warranto, and subsequently, Mr. P.J. Thomas was forced to step down as the Central Vigilance Commissioner of India. So, by using this writ of quo warranto, so it can be used against any person who is holding a substantive public office. So, in this case, against Mr. P.J. Thomas, there were certain criminal cases that is pending against him. And as per the rules and the respective laws in our country, a person who is appointed as a Central Vigilance Commissioner should have an impeccable integrity, should have a very clean service record. So the court found that was not there, and hence he was forced to step down. And what made the court to give such a direction? Because the writ of quo warranto was filed against him. So before I proceed to the next question, let us also briefly understand about the other types of writs. So what does mandamus means? Mandamus means that the court is directing the government to perform certain duties, or any public authority to perform certain duties, which basically means we command. And why they give that particular command? They give that particular command because the state has failed to perform certain duties, a result of which certain rights of the individual has been affected. Say for example, a number of petitions are filed in the courts to reduce pollution. Now, the Supreme Court has already declared that right to clean environment is a right, fundamental right implied under Article 21, and whose responsibility is to provide a pollution-free air? It is the responsibility of the state. So many times the writ of mandamus has been filed against a state to reduce the pollution, and then the writ of prohibition. Writ of prohibition is usually issued by a higher court against the lower court in order to prevent the lower court from exceeding its jurisdiction. So this is basically which is also called as we forbid, or it is usually called as a stay order. Okay, that is what is writ of prohibition. So the writ of prohibition is basically preventive in nature. It prevents the lower court from exceeding its jurisdiction. But in case if the lower court has already exceeded the jurisdiction, then we can make use of the writ of certiorari. The writ of certiorari is curative in nature. So if any lower court has already exceeded its jurisdiction, and then that order can be quashed by an order of the higher court, and that is what is called as writ of certiorari. And there is basically one more writ, that is writ of habeas corpus. So habeas corpus is basically used to determine whether the detention of an individual is illegal or not. If the detention is illegal, then the court will give him the remedy, and if the detention is legal, then the court may not give him the remedy. So that is basically the writ of habeas corpus. Let's move to the next question. So before I get into this particular question, let me just give the context in which this particular question becomes relevant for the examination. Recently, there was a petition that was filed in the Supreme Court, and then a few days back, the Supreme Court has also passed the judgment that the offence of adultery can continue to be a punishable offence in case of the members of the armed forces. That means if the members of the armed forces, if they engage in adultery, so adultery, you might be having an idea, it is kind of sexual intercourse between the individuals outside their marriage, of course on the basis of consent. So that can be seen as what is adultery. For the armed forces members, the adultery can continue to be an offence. That means what about the normal civilians? For them, adultery is no longer a punishable offence. Yes. For which you'll have to understand the Joseph Shine case. There, 2018. And also section 497 of the Indian Penal Code. Under section 497 of Indian Penal Code, adultery was considered to be a punishable offence. Any form of sexual intercourse outside the marriage, even if it is on the basis of consent, that was considered to be a punishable offence under section 497 of IPC. But that was before the Joseph Shine case in the year 2018. In 2018, this provision was struck down and it was no longer considered to be a punishable offence in case of the civilians. Now, why the court found that this particular section 497 of IPC is basically violative of Article 14, 15 and Article 21 of the Constitution, especially that of women, because it is not placing women equal to that of men. And stating all these grounds, it has been already struck down and it is no longer part of the punishable offence. It's no longer a criminal offence. But however, subsequently a matter was brought to the Supreme Court that the armed forces want the adultery should continue to be an offence. And in this context, it is also very important that we understand Article 33 of the Constitution. The question that can arise in your mind is, can there be different set of rights when it comes to the ordinary civilians and when it comes to the armed forces? While the ordinary civilians may not be punished, is it possible for the armed forces personnel to be punished under the same offence? That's very much possible, because Article 33 of the Constitution says that the Parliament shall have the power to make law, and by that law they can alter or they can completely take away or they can modify the fundamental rights that can be exercised by the members of the armed forces. Because armed forces requires a lot of discipline, and to ensure the discipline, to some extent even their fundamental rights can be curtailed under the Article 33 of the Constitution. So based on the power that is given to the Parliament under Article 33, already a number of acts has been passed, like the Army Act, Navy Act, Air Force Act, etc. So they actually curtail certain amount of fundamental rights. Say for example, the armed forces members does not have the right to form union, which otherwise is available to the normal citizens. So in this way, their rights can be curtailed by virtue of Article 33 of the Constitution. So with this understanding, let us try to solve this question. Look into the first statement. The fundamental rights of the armed forces and the other analogous forces. It is not only for the armed forces, it can be for other analogous forces also under Article 33 of the Constitution. So the other analogous forces may include the paramilitary forces, the police forces also sometimes. So other analogous forces may be restricted by an act of Parliament. So this is very much true. But however, one thing that you have to remember here is the Constitution empowers only the Parliament and not the state legislature. Okay, so this particular statement is true. Come to the next statement. Under certain circumstances, the state legislature can make laws to restrict the fundamental rights of the members of the armed forces. Now, this can never be possible. It is only the Parliament which has the power to do that and not the state legislature. Okay, so this particular statement is wrong. So which of the statements given above are incorrect? So the incorrect option would be option B. Let's move to the next question. Look into the next question. Which of the following policies of the state are protected under the concept of equal protection of laws? So first of all, you'll have to understand as to what is this equal protection of laws. There are few fundamental rights. It's very, very important for your examination. For example, Article 14, Article 19, Article 21. At any time, the question can come from these areas. Now, what is Article 14 is saying? Before I solve, let me briefly touch upon this Article 14. Article 14 talks about two things. One is equality before law. And the second thing is the equal protection of law. So we are basically concerned about the equal protection of laws for this particular question. But what is equality before law? So equality before law means that everybody shall be treated equally. That there should be a law, and according to the law, everybody has to be treated. So nobody is above the law. The law is supreme in this particular country. This is basically to avoid any form of arbitrary authority which shall be exercised by the state. So that is equality before law. But however, what is this equal protection of law? Now, equal protection of law is on the principle that the law shall be equally applied only when the people are equally placed in the society. That means, to put it in a very simple way, if all the people are equal in the society, then we can have equal set of laws. But if the people are not equally placed, somebody is rich, somebody is poor, somebody is advanced, somebody is backward in terms of their social and educational advancement, how can you apply the equal set of laws to these people? So if you apply that, you can apply, if you apply that, it would not ensure what is called as social justice. It will not ensure social justice. So this concept of equal protection of law is based on the idea of social justice. So what is social justice? It is to provide equal opportunities. It is to redistribute the wealth in the society. It is also to provide equal privileges to the people. So that would amount to what is called as social justice. So that means there can be certain special privileges that can be given upon, because those people are really deprived in terms of their social and educational backwardness. Those people are really deprived in terms of their opportunities. So they may be given certain extra privileges by the state. So here there may not be equal treatment. It is not the state is equally treating. If the state is equally treating, then it may not amount to justice to the people who are already backward. But the state is trying to provide what is called as social justice to these people. So based on that particular understanding, let us try to solve these statements. So here the question is, which of the following policies of the state is protected under the concept of equal protection of laws? So you might understand that, see the progressive taxation system. Under the progressive taxation system, not everybody is paying equal tax. Somebody is paying 5% tax, somebody is paying 10%, somebody is 30% tax. Now, why this segregation is there? Why this slab is there? because the income of these people are not equal. So they fall under different categories in terms of the income that they make. So you cannot make them to pay equal tax when their income itself is different. And so this is exactly based on the principle of what? Social justice. Reservation in public employment. So many students might have doubt in their mind that the idea of reservation itself is violative of the principle of equality. It may violate the principle of equality, but they are applying the principle of what? They are applying the principle of equal protection of laws. Because in the opinion of the state, people who are given the reservation, they are not equally placed, and hence they have to be given equal opportunities. Unless and until this opportunity is given, they will never be able to get into the job and they will never be able to develop their life. So this is also true. This is also true. Criminal laws in our country. If you see, most of the criminal laws, I would say that they treat everybody equally. So there is no social justice measure here. So it is based on the principle of equality before law, not equal protection of law. So this particular thing is wrong. Special rights of persons with disabilities. Say for example, the Disabilities Act is there. It provides a number of special protection, in fact including reservation and other special privileges for the persons with disabilities, because their opportunities is much lesser in comparison that of a person who is physically able. So this is also based on the principle of what? It is also based on the principle of equal protection of laws. So with this understanding, try to solve the question. Choose the correct answer from the quotes given below. What would be the right answer? If you exclude option number 3, statement number 3, then the right option would be 1, 2, 1, 4. So that is option C. Next question. Before I get into the question, what is the context of this particular question? Recently, in one of the public forum, the Honorable Vice President of India has questioned the doctrine of basic structure. He not only questioned the doctrine of basic structure, he also questioned as to the power balance between the judiciary and the legislature, because recently the judiciary in the year 2015 has struck down the National Judicial Appointments Commission Act. NJSA Act was struck down, we all know that, in the year 2015. So he also questioned that what is the position of judiciary vis-a-vis the legislature. And he has also mooted a question on the idea that is the concept of separation of powers balanced under the Constitution. So in this context, whatever we are going to discuss becomes very important. Whatever has happened with regard to the doctrine of basic structure is very important. The concept of separation of powers is also very important for your examination. Now we all know that this doctrine of basic structure is nowhere mentioned in the Constitution. It is not defined in the Constitution. There is no explicit mention of this. It's merely a judicial innovation in the Kesavananda Bharati case in the year 1973. Kesavananda Bharati case in the year 1973. Otherwise, there is no mention of this. What is the opinion of the court in this particular case? That the power of the Parliament to amend the Constitution is not unlimited, rather it is limited. So the power of the Parliament under Article 368 is not unlimited, rather it is limited. It is limited to the extent that they cannot destroy the basic structure of the Constitution. What is this basic structure? It has not been defined. The Supreme Court said that we will decide as to what constitutes the basic structure as and when the matter is brought in front of the courts. So starting 1973, a number of provisions has been declared to be part of the basic structure. With this basic information, let us try to get into the question. Statement 1. A constitutional amendment can be violative of the fundamental rights. Yes, very much. A constitutional amendment can very well violate, or it can even take away the fundamental rights. Say for example, the right to property was taken away as a fundamental right. It is no longer a fundamental right. It can take away. So that's not a problem. So constitutional amendment can be violative of the fundamental right. The only thing is, a constitutional amendment can take away the fundamental right as long it is not declared to be part of the basic structure. Okay, that's the only restriction you'll have to remember. Statement number 2, a constitutional amendment can be challenged only on the grounds of violation of the basic structure of the constitution. This is very much true. This has also been declared by the Keshavananda Bharati case. Can we declare any constitutional amendment? Can the courts declare any constitutional amendment to be void? Or what is the ground on which they can be challenged? Only if the constitutional amendment is violative of the basic structure. You cannot challenge it merely on the grounds that it is violation of the fundamental rights. Okay. So the only limitation for the parliament to amend the constitution is on the grounds of basic structure. So this is also true. The basic structure is well defined under Article 13 of the Constitution. Article 13 only defines as to what is law. Article 13 does not define the basic structure. Neither Article 13 nor anywhere in the Constitution it is defined. Okay. So this particular statement is wrong. So which of the statements given above are incorrect? So the right answer is option D. Okay. So let us go to the last discussion for today's important topics. Let us quickly move to the next question. Before I discuss this next question, what is the context and why this particular question becomes very relevant? Recently, there were demands for a creation of new state which is called as Bill Pradesh. The Bill Pradesh would comprise, if it is created as a new state, would comprise certain tribal parts in the states of Gujarat, Rajasthan and Madhya Pradesh. So the tribal community in these regions have already demanded that they wanted to have a separate state of Bill Pradesh. So in this context, we'll have to understand what is the provision in the constitution. Do you have any provision, if at all tomorrow the government wanted to create a separate state of Bill Pradesh? Can it be done under the Constitution of India? So in this context, Article 3 become very, very important for your examination. So what Article 3 is saying? Article 3 is giving the power to the Parliament to make a law, and by that law they can reorganize the states. What do you mean by reorganize the states? When I say they can reorganize a state, they can increase the area of a state, they can diminish the area of a state, they can alter the boundaries of the state. So all these things can be done. They can change the name of the states, they can merge two states. So all these things can be done under Article 3 of the Constitution. But who has the power to do that? Only the Parliament. Is it necessary for the Parliament or for the government, the central government, to take any permission from the states? They don't have to take any permission from the states, but only thing that is mentioned in the Constitution is whenever a bill is to be presented in the Parliament with regard to the reorganization of the states, the bill has to be referred by the President to the concerned state legislature to take their opinion. The state legislature may give their opinion to the President. May give their opinion to the President, but however, this opinion is not binding upon the President. And then the President gives the recommendation, the bill may be introduced, and then once a bill is passed in both houses of the Parliament, and when the President gives the assent, automatically the bill becomes an act, and accordingly the changes can reflect in both Schedule 1 and Schedule 4 of the Constitution. And any change that would happen in Schedule 1 and Schedule 4 of the Constitution does not require a constitutional amendment in this particular case, because it is not deemed to be an amendment under Article 368. So probably what you should remember the provisions of Article 3, what will happen to Schedule 1 and Schedule 4, whether there is a need for approval of the state legislature, no need, and there is a need for prior recommendation of the President before introducing these bills. So all these things are very, very relevant for your examination. So with this information, let us go to the question. Statement 1, creation of new states in India by reorganizing the existing territory can be done only by the Parliament of India. So this is very much true. The state legislatures do not have the power to do that. It is only within the power of the parliament. 2. A union territory can be conferred the status of a state by an act of parliament, and vice versa is not possible. It's very much possible. An union territory can be conferred a status of a state, that is very much possible. A state can also be converted into a union territory. That can be very well be done by the parliament under Article 3 of the Constitution. So this particular statement is wrong. Statement 3. The approval of the concerned state legislature is mandatory before reorganizing the state. I have already said the approval is not mandatory. Their approval is not mandatory, or there is nothing which is called as approval. It is only that their opinion is taken. It's only that their opinion is taken. Otherwise, their approval is not mandatory. Okay. So with this, what is the answer to this particular question? So this particular statement would also be wrong. Which of the statements given above are correct? What is the correct statement? The correct statement would be option 1 only. So remaining things are not correct. Only statement 1 in this regard is correct. So these are the list of important topics for today's discussion. So in this way, we'll be covering around 100 topics, which I'm very sure that could help you in getting the most of the questions right in your preliminary examination 2023. Thank you very much. God bless.